Hello, I'm Orange County Executive Steve Newhouse. Orange County government is committed to having a workforce that adheres to the highest ethical standards. This training video will explain to you what behavior is expected in respect to the Orange County ethics law. I want to thank all my coworkers who helped make this video possible and thank the entire county workforce for all the hard work that they do to make Orange County a great place to live and work.
Welcome to today's training session concerning the county's new Code of Ethics. My name is Sharon Berlin. I'm with the law firm of Lamb & Barnosky, and the county has asked me to come in and train its employees concerning this Code of Ethics, which was amended by the county legislature in 2017. The Code of Ethics can be found on the county's website and in the materials you will receive today. It is found in Local Law Number 1 of 2017. The provisions of the county's Code of Ethics, as well as the New York State General Municipal Law, relate to your employment here while you're working at the county, and as well there are provisions that pertain to you even after you're no longer with the county. So we're going to today highlight some of the most important rules that may apply to you, and we'll try and talk about the reasons for those rules. Throughout today's training, I plan on using various hypothetical situations as examples. I want to be clear that those are all entirely fictional. It does not relate to anything that has happened in the county or to any county employee. They are fictional scenarios that I made up. Today's training is designed to provide you with general guidance and not specific advice. Obviously, you may at points have questions. Feel free to ask them today, but in the future you may have questions also. If you have a question in the future and you need guidance, you should first speak with your supervisor. If it's something that you're comfortable speaking with your supervisor about. If you don't want to speak to your supervisor, or if you wish to go directly, you may consult with the Board of Ethics. The Board of Ethics will provide written advisory opinions to county employees regarding anything having to do with the Code of Ethics or the State General Municipal Law provisions that relate to ethical issues for county employees. The Board of Ethics will issue guidance to you in the form of a written advisory opinion concerning something that is to happen in the future. They will not give you guidance and a written advisory opinion about something that has already occurred. So if there is something that you're concerned about that may pose an ethical issue, you need to consult with them before you act on that matter. The county's Code of Ethics is actually a little bit stronger than what the state law is. And so if you have worked in another municipality in the past, you may have received training in terms of the ethical provisions under the state's general municipal law. You need to keep in mind that the county's law goes even further than the state law. So if you have questions in the future, you need to direct those to the county's Board of Ethics. If you consult with somebody who is only familiar with the state law, they may not make you aware of the additional restrictions that are contained in the county law. Now, the provisions that I'm going to talk to you about now concern your conduct while you're here as a county employee. And only through the county employees all following these provisions can we best ensure the integrity of government and that employees' loyalty is to the county and is to their position with the county, and that there shouldn't be questions about other outside interests that you may have that could be perceived as impacting upon your decisions while you're working at the county. So what does this mean for you? The Code of Ethics focuses on establishing reasonable standards of ethical conduct to make sure that county officers and employees serve and benefit the public, and that they do not obtain unwarranted personal or private gain in the performance of their official powers and duties. So, you must be sure that your personal interests, such as a second job, a side business, or property and investments, do not create a conflict of interest with your public work. So to better ensure that you have undivided loyalty to the county, there are a number of rules that apply to minimize the appearance of improprieties or you're having an actual conflict of interest. So, for example, you can't use your official position here in the county or your office to take action or to refuse to take action in a matter that you know or you have reason to know could provide a personal financial benefit or that would give an unwarranted privilege or exemption to you, to your outside employer, business or prospective employer, to your relative or immediate family member, which includes your spouse, your unmarried child or stepchild under the age of 18 who resides with you, or to anybody who's declared as a dependent on your tax return. You also can't take action or refuse to take action related to your public office where it would provide a financial benefit or an unwarranted privilege or exemption to a customer or a client, somebody you've done business with within the last 24 months, or to the outside employer, business, or prospective employer of your relative or immediate family member. So if you have a situation where you may receive a personal benefit or privilege, you need to stop and speak with your supervisor because you are going to have to recuse yourself from that matter, which means that you are going to have no further involvement in that matter. You're going to have no further action in that matter. To recuse yourself, you would promptly inform your supervisor in writing, and you would file with the Board of Ethics a signed statement disclosing the nature and extent of the conflict which forms the basis for your recusal, and you would immediately refrain from any further participation in that matter. So, as an example, maybe you work in an office that processes applications to use one of the county's parks that has a pavilion, and you have a second job, not with the county, you have a second job, and your other employer applies for a permit to use that pavilion, and they put in that application to your office, and you're the person who normally handles those applications. You can't have anything to do with that application. You can't process it, and certainly you can't waive any fees or have anything else to do with it. You would use the same recusal procedure. That is, you would promptly inform your supervisor in writing, and you would file with the Board of Ethics a signed statement disclosing the nature and extent of the conflict which forms the basis for your recusal, and you would immediately refrain from further participation in the matter. Now, if you, your spouse, child, sibling, or a member of your household currently, or somebody who has lived in your household within the last 12 months, has or will have a direct or an indirect interest in an actual or proposed contract with the county. It could be a purchase agreement, it could be a lease agreement, it could even be an oral agreement, or some other type of professional dealing with the county. You have to exclude yourself from any discussions or negotiations about that matter, and you have to disclose that interest. And there is a specific provision in the Code of Ethics about disclosure. So to disclose that interest, as soon as you have knowledge of the actual or the prospective interest, you have to publicly disclose the nature of that interest in writing. So you send that in writing to your immediate supervisor. It could be an email, it could be a letter, it could be a memo. You send it immediately to your immediate supervisor and to the clerk of the county legislature. And what happens with that document is that it becomes part of the written records of the legislature. It becomes part of the official records. It is presented to the legislature, and it becomes part of that record. And the clerk of the legislature also files that disclosure statement with the county executive and with the Board of Ethics. You then have nothing else to do with that matter. You recuse yourself, you take no further action, and you have no further involvement, not even in the discussions of that matter. You have a duty to avoid creating any conflicts with your official duties or investing in any transaction or business that would create a conflict with your official duties here in the county. So you can't invest in a business that's doing business with the county when being an owner of that business would create a conflict with your official duties here. So for example, if you're responsible for ordering the office supplies for the county, you can't become an owner, even a part owner, of an office supply business that contracts with the county to sell office supplies. So say, for example, you work for the county in a health clinic, and you also have outside employment working for a private medical practice. It would create a conflict for you to then be referring patients from the county's health clinic to that private medical practice. Another example is, say you work for Child Protective Services, CPS, and there's a family that you interact with through your job, and they are looking for a babysitter. For you to take a job babysitting for a family who you're dealing with in your official capacity here for the county would create a conflict of interest that would violate these rules. The next topic that we're going to talk about is nepotism. And nepotism involves the hiring of relatives. Now, lots of people who work for this county are related to other people who work for the county. And that is not a problem. We want to be 100% clear on that. You can have relatives, even a spouse, who is also employed by the county. However, the county's Code of Ethics requires that if somebody is related to you who is a first cousin or closer to you through blood as well as through marriage, that if you have a relationship, first cousin or closer through blood or marriage, and that person is seeking a contractual relationship with the county or an employment relationship with the county, then you are required to disclose that relationship upon learning that that person is seeking a contract with the county or employment with the county. And what your obligation as an employee is that at the earliest opportunity after you learn that that person is seeking the contract or is seeking employment by the county, or as soon as you gain knowledge that the person is seeking that relationship, you have to send a written disclosure statement to the county's Board of Ethics. You need to identify that you work for the county, what your job title is, what department you are employed in, and the person to whom you are related who is seeking either a contract or an employment relationship with the county, and how that person is related to you. Any questions?
Question. If the county hires a relative, and if you're not directly involved with their hire, do you still have to notify the Board of Ethics?
That's a great question. The question is, if the person is being hired and you are not in any way involved in the hiring, do you still have to disclose that to the Board of Ethics? Yes, absolutely. Anybody who is related to you, who is a first cousin or closer through blood, or somebody, a first cousin through marriage, you need to disclose that even though you have no role in that contract or in that employment relationship. It just has to be disclosed. It doesn't mean that that person cannot be hired. There are lots of people who are related and who work for this county, and sometimes some people have a lot of first cousins, and you may not know right away that that person is seeking the relationship with the county. As soon as you learn of it, even if the person has already been hired, you should send in your written disclosure to the Board of Ethics.
So it's incumbent upon the current employee to notify the chairman of the Board of Ethics?
Yes. Yes, it is incumbent upon them, and there are additional rules that apply. If the person who is doing the hiring is actually related to the person, then they have to be excluded from that process. But that's beyond the training that we're doing for this group of individuals. But some of the supervisors who are responsible for hiring do have additional obligations. The next topic we're going to talk about is gifts. At times, you will receive gifts from people outside the county that relate in some way to your work here in the county. It may even be a gift from another county employee. Now, as a county employee, you are prohibited from accepting or soliciting a gift or gifts from the same individual or entity in a 12-month period that have a total value of $75 or more. So you're prohibited from accepting one gift that costs $100, and equally you're prohibited from accepting 5 smaller gifts that will exceed $75 in value. So we're not saying that your family members, that your parents, your spouse, your children, others living in your household can't give you a gift. There is an exclusion where a gift is based upon your personal relationship with that person, such as your close personal friends, your family members, your people who live in your household. Also excluded from the definition of gift are items such as free meals when you're at a professional conference, awards, plaques, promotional items, those things you get, the t-shirts with the company logos or the pens, items that have a logo that don't have any real resale value. Those are excluded from the definition of gift, so it doesn't count towards that $75. There's also an exclusion for food or beverage valued at $20 or less, so long as what you receive from the same individual or entity does not exceed a total of $75 in any 12-month period. And there's an exclusion for complimentary attendance at a bona fide political or charitable function. So if you receive a ticket to go to a charitable event, that would be excluded from the definition of a gift. Now, regardless of the value of any particular gift, you are prohibited from accepting a gift or any type of financial benefit at any time where it could reasonably be inferred that that gift was intended to influence you in the performance of your official duties here for the county, or that it was intended as a reward for your work or for your official action here in the county. So you cannot accept a gratuity for the work that you perform here in the county. You can't accept a payment for expediting an application or a permit. You can't accept any additional payment for doing your job here in the county. So sometimes you receive a gift, particularly around the holidays. Sometimes a vendor will send over a gift that is too expensive. It's well beyond the $75. And I have heard various ideas about what you might do with that gift. You need to not accept it. You need to don't sign for it and send it back. You can't send it to another department that isn't dealing with this vendor. If it was a gift that you couldn't accept, you can't send it to the department down the hall. They can't accept it either. If you get a case of wine, the case of wine is normally valued at more than $75. You can't say, I can't accept this because it's worth more than $75, but the whole department can if we each take a bottle of wine. You can't divide it up so that each person gets a gift valued at less than $75. If you can't accept it in the first place, dividing it up doesn't work. You also can't say, I can't accept your gift. I can't accept those tickets to the World Series, but my wife can. She doesn't work for the county. You can't accept under any of those circumstances. If it's a gift that you couldn't have in the first instance, you can't have it sent to somebody else on your behalf. The county has lots of equipment and resources, but that equipment and resources can only be used for county purposes. You cannot, under any circumstances, use county resources for your own private purposes or for your own private business. So, for example, if you have a project that you're working on at home, you cannot borrow any equipment from the county, even if it's just for a night. You cannot take the county's equipment home and work on your own home, or if you have a business, on somebody else's home. You can't borrow a bulldozer, or if the bulldozer happens to be passing near your neighborhood, you can't borrow it and use it to dig your own well. The county's equipment is only to be used for official county purposes, Likewise, you can't use your office here in the county for any private business or for any private purposes. You can't use your phone or your email to run your own private business at the same time as you are here working in the county. That's not what the county's resources are for. The next topic is use of the county's official name, seal, or authority. The county's official name, seal, and authority cannot be used for any private or non-county purpose or in connection with any private or non-county function, organization, entity, group, or event unless you receive advance authorization to do so. Political activity. Now, the county's Code of Ethics prohibits any county officer or county employee from directly or indirectly using his or her authority or influence, their official influence, to compel or to induce a subordinate to participate in an election campaign or to contribute to a political committee. So this means that you can't ask somebody who works for you, a subordinate, to work on a political campaign, and it doesn't matter whether you're asking them while you're at work or during a break or when you're out to dinner with them. It's prohibited no matter where you're doing it. You can't ask a subordinate to work on an election campaign or to contribute to a political committee. Now, in the course of your employment with the county, you at points will probably become privy to confidential information as part of your official duties. You cannot disclose that confidential information. You can't use it for your own or anybody else's personal interests. Before you disclose any information that might be considered confidential, you need to speak to your supervisor, and you will need to seek a written determination from your department's records access officer. Now, that obligation to keep confidential information confidential continues forever. It continues when you're no longer employed by the county. It continues on as long as that information exists. It remains confidential information that you cannot disclose.
How do you know what's confidential and what's not?
That's a great question. How do you know what's confidential information and what's not? And there is no clear definition of what is confidential information. The law doesn't contain a definition. Any information that wouldn't be subject to disclosure, if somebody made a Freedom of Information request, a FOIL request, certainly is considered to be confidential information. Any information that's discussed in an executive session meeting of a board or the legislature, clearly that's confidential information. But there's other information that people learn about in the course of their employment, whether they're an attorney with the county or they're working with children, students. There's all kinds of confidential information that different employees become privy to. And that's really why they need to address this to their supervisor and to their department's records access officer so that a determination can be made whether that information is confidential. Now, sometimes employees of the county have other jobs. They have outside jobs that are not for the county. There's nothing that prohibits you from having another job. However, that other job has to be something that does not in any way create a conflict with your official duties with the county. So, for example, if you're responsible for assigning service providers to county clients, you can't go and work for an outside agency that provides services to county clients and then assign those matters to your outside agency and then go and perform those services for the clients that you have assigned to that outside agency. Now, while you're working for the county, you are allowed to seek a new job, a new private employment, whether it's a second job or your next job after you're no longer working for the county. You cannot, though, solicit or accept private employment or render services for your own personal benefit when you're doing that creates a conflict or impairs the discharge of your official duties here for the county. So you also have to be sure that your department doesn't have any procedures or regulations concerning outside employment. You may need to speak with a supervisor to make sure that there are no restrictions within your particular department. So you need to check on that before you go and seek another position. Now, there are also, not related to your employment, but there are also times where you need to appear before a county office or a county agency for your own personal reasons, for your own personal benefit. While you're still working for the county, you are allowed to do so. You are allowed to appear on your own personal behalf. You cannot, however, do so on behalf of anybody else. So this means you can't represent a private interest or your brother-in-law before any county agency or department while you were employed by the county. For 2 years after your employment with the county ends, you cannot represent or render services to a private person or to an organization in connection with any matter that involved the exercise of discretion before the county office where you worked, unless you are requested to do so in writing by the county executive or the chair of the legislature. The Code of Ethics contains a 6-month restriction for appropriators or authorizers. If you were responsible for appropriating funds for the effectuation of, or for negotiating or authorizing a contract, or for signing a contract, you may not ask for, pursue, or accept a private post-government employment opportunity with any person or entity who actually received the contract while the matter is pending or within 180 days of its final disposition. Many of the provisions contained in the county's Code of Ethics can be waived by the county's Board of Ethics. If for some reason you believe that you need a waiver from one of those provisions, you need to submit a written request to the Board of Ethics for a waiver. The restrictions on post-government employment may be waived by the Board of Ethics, where the appropriating, negotiating, or contracting person had no direct involvement with the selection of the contractor, or where the involvement was limited to issuing an approval or appropriation for a recommended contractor that the approver or appropriator was not otherwise involved in selecting. Or the provisions may be waived where the restrictions would cause a financial hardship for the county officer or employee.
Does the waiver need to be submitted prior to whatever you're attempting to waive?
Yes, a waiver should be submitted before you engage in any type of action that might violate the Board of Ethics. So yes, you definitely want to get a waiver up front. We do recognize that the updated Code of Ethics was adopted and implemented immediately. So there may be situations where somebody is now in violation of the updated Code of Ethics and where they may need to seek a waiver where they're already in that situation. But anything that is coming up in the future, and particularly after somebody has been trained, you really do need to request that waiver up front before you are in violation of the Code of Ethics. In terms of how you would apply for a waiver, the form for requesting a waiver is available through the Secretary to the Board of Ethics. You may apply for a waiver from any of the standards that are set forth in the law, but you will have to show that there is a compelling need for the waiver. If you do submit a request for a waiver within 5 business days of its receipt, the Board of Ethics will acknowledge receipt of your request. The Board of Ethics will try to grant or deny the waiver request within 10 business days of receiving sufficient information upon which to render its decision. Your request for a waiver will be deemed abandoned if you do not provide information that is requested by the Board of Ethics within whatever time frame is established by the Board of Ethics.
Sharon, what's the difference between a written advisory opinion from the Board of Ethics and a waiver from the Board of Ethics?
The written advisory opinion is guidance. It's guidance, and that guidance only pertains to the particular employee to whom that guidance is given and for that particular situation. It is not a waiver. If there is a provision that needs to be waived, if there's a provision in the Code of Ethics from which you need a waiver, you're going to have to apply for that separately. It may be that when you receive the written advisory opinion, the Board of Ethics indicates that you're going to need a waiver and that you will have to apply for a waiver from that particular provision. And then you will have to submit that application and they will have to decide whether they will grant that waiver. But a written advisory opinion is not the same as a waiver. We hope that today's training has provided you with guidance in terms of carrying out your duties here in the county. And with everybody following the Code of Ethics, we should be able to enhance the public image, transparency, confidence, and the integrity of our county government, as well as all of the important work and the reputations of each of the county's employees. So thank you all.